When a permanent resident or a visitor seeks to enter the United States, the person is screened at the port of entry for what is called admissibility or inadmissibility. Persons who are deemed to be inadmissible are prevented from entering the country, and those who are deemed to be admissible and have the proper documentation to enter the United States are permitted entry into the country. I will focus in this video on one category of inadmissibility, one area of the law that creates issues and the need for caution, and that has to do with an immigration benefit that is called a provisional waiver. A provisional waiver usually is a process that allows persons who are unlawfully present in the United States to be able to get a waiver of the penalty that is normally applied to persons who are unlawfully present in the United States. Unlawful presence in the United States results in one of several grounds for inadmissibility, which means that a person unlawfully present in the United States who leaves the country and seeks to re-enter would be prevented from entering because of one of several grounds of inadmissibility. So the provisional waiver allows a beneficiary of immigration benefits to petition the United States government to waive that penalty. Let's talk about what really is meant by unlawful presence in the United States. Unlawful presence in the United States as it pertains to the provisional waiver and adjustment of status refers to persons who enter the United States without being inspected at the port of entry. In a previous video, I addressed the question of what is meant by entry through inspection and what is meant by illegally entering the United States or illegal entry into the United States. And you should take the time to look at that video. You could find it on my YouTube channel and get a better understanding as to what is meant by entry without inspection. An understanding of entry through inspection would help you to have a better sense as to whether you fall within the category of people that would be deemed to be unlawfully present in the United States and therefore have a hurdle that you must cross if you are to adjust your status here in the United States. So a person who is unlawfully present in the United States may have a U.S. citizen or permanent resident spouse or immediate relative who files an immigration petition for that person to receive immigration benefits or an immigration benefit such as lawful permanent residence. A person who enters without inspection and is unlawfully present in the United States is not able to adjust his or her status here in the United States. Enters the waiver or the provisional waiver. The provisional waiver allows such a person to file an application with the government here in the United States while still being present here in the country to waive the grounds of inadmissibility. So you are leaving the United States with the assurance or a great level of assurance that you would not be prevented from re-entering the country, and the processing of your petition for a residency visa would not be denied or terminated because of that inadmissibility problem that you have. And that is the benefit of the provisional waiver. But let's understand the kicker, and let's understand that the problems that you need to be aware of if you're not going to find yourself stranded overseas and prevented from returning. First thing, the provisional waiver only applies to persons who are unlawfully present in the United States and do not have any other grounds for inadmissibility applicable to them. So if you're unlawfully present in the United States, but you have other grounds of inadmissibility also applicable to you, the provisional waiver will not work for you. There are instances where people apply for a provisional waiver and the waiver is approved. Usually, if you have other grounds of inadmissibility, at the time of processing the provisional waiver, if those grounds of inadmissibility are discovered, the provisional waiver is denied. But there are instances where other grounds of inadmissibility may not become known at the time the provisional waiver is processed. Or if those grounds were not existing at the time that the provisional waiver was processed, there might be additional grounds that develop between the time that the provisional waiver was processed and the time that your interview is scheduled and is conducted at the consulate outside of the United States. So, whether the additional grounds for inadmissibility existed prior to the approval of the provisional waiver or whether they existed after, if they become known at the time that your visa interview is being conducted at the consulate outside of the United States, the provisional waiver will be automatically vacated. It would be automatically nullified. Sometimes you may think that there is no other grounds of inadmissibility that may confront you, but a background check is helpful because there might be things in the record that you are unaware of. For instance, some people who are victims of identity fraud may have persons commit crimes in their names that they are not even aware of. Here is another problem, or something else that you need to be careful with. There are instances where a person who is unlawfully present in the United States may have an existing order of removal or a prior order of removal. The order may not have been acted upon by the government. As a result, you are still present in the United States. And then you have an approved petition by an immediate relative. If you have a prior order of removal, the provisional waiver will not work for you. And if you obtain that provisional waiver and leave the country, and that prior order of removal is detected or become known at the consulate that you do the interview for the visa, your provisional waiver will be of no use because that prior order will serve as a basis to prevent you from re-entering the country. It will operate as one of the grounds of inadmissibility. Persons who were in immigration proceedings prior to getting their residency petition approved and prior to obtaining the provisional waiver should also take additional steps to ensure that there is no pending immigration case against them. If there is a pending immigration case, even though you have that provisional waiver, if you leave the country while that case is pending, your departure will be deemed a voluntary departure. It will be deemed as if you have self-deported, and that voluntary removal from the country will operate as a bar to your re-entry to the country. When you go to the consulate with the provisional waiver, it will not help and you will find yourself stranded outside of the United States, unable to return. There are also instances where you might have been in immigration proceedings and the proceedings might be administratively closed. An administratively closed proceeding is not one that has terminated or one that has been dismissed. it is administratively closed, which means that it could be reopened. What you must do if you obtain a provisional waiver before leaving the country is reopen that case and have the government dismiss the case or terminate the case. The case must be dismissed or terminated before you leave.